Case is set for a 15-minute argument. I would ask counsel to be mindful of the time.
Good morning, Your Honor. My name is Howard Srebnick. I'm joined by Richard Strafer at counsel's table. We represent Arturo Godinez. And with the court's indulgence, I would request a 3-minute reservation for rebuttal.
Very well.
Arturo Godinez stands convicted of 3 counts. 2 counts under the RICO statute, 1 count under organized scheme to defraud. The state's theory of prosecution, one that was endorsed by the trial judge through the jury instructions, is that Mr. Godinez defrauded consumers by distributing medication, prescription medication, without a wholesaler's license and without so-called pedigrees, even if the medications were genuine, safe, and effective. So the question presented today for this panel is whether the wholesale distribution of genuine medication, albeit without a license, constitutes fraud within the meaning of the organized scheme to defraud statute, within the meaning of the mail and wire fraud statutes of federal law, which in this case were incorporated into the state RICO charge. We submit, based on both state and federal case law, that the gravamen of a scheme to defraud requires that the state prove an intent to cause financial injury, pecuniary harm, economic harm on the purchaser. And therefore, a consumer is not defrauded merely because he or she acquired medications down the line from a wholesaler who did not possess a license, so long as the medications were genuine, safe, and effective as manufactured by the manufacturer.
But counsel, this case concerned more than just a person who didn't have a license. I mean, wasn't there at least some testimony about maybe obtaining the drugs in a way that there was some question, at least, about their whether they might have been adulterated, whether they might have been tampered with. I mean, they weren't received through the normal channels, with or without a pedigree. Some of the drugs were not received through the normal drug distribution channels.
I understand Your Honor's question.
I guess that's my question.
When the court refers to the normal channels, I assume the court is referring to those channels as required by Chapter 499 of state law. As to Mr. Godinez, different from any other defendant in this multi-defendant case, the evidence was undisputed. The medicine that's alleged to have been distributed by Mr. Godinez was in no way contaminated, in no way tampered with, in no way adulterated. It was genuine medication. 3 witnesses testified for the state, and all 3 were together in this point. Witness Novacell at volume 17 of the record, witness Siegel at volume 14 of the record, and witness Pena at volumes 23 and 24. The only witnesses to testify about Mr. Godinez were all unanimous that the medications that Mr. Godinez allegedly distributed were pure and genuine, as the manufacturer made them. No indication, and the state conceded this in closing argument, no evidence, no argument, no indication that the medicines were in any way tampered or contaminated with, Your Honor. And that therefore frames the legal issue for this court. Can the state convict someone for fraud merely because he or she doesn't have a wholesale license, or merely because he or she acquires the medicine outside what Your Honor referred to as the normal chain? And our answer to that question is, it's only a fraud if the medicines are something other than what they are purported to be, and that is genuine, safe, and effective medication. Perhaps the state could have charged Mr. Godinez under Chapter 499 for not having a license, but the state chose not to do that. Perhaps the state could have charged Mr. Godinez under Chapter 499 for not maintaining pedigrees. The state chose not to do that. The state did charge other defendants with those crimes in the indictment, not Mr. Godinez. Instead, as to Mr. Godinez, the state pursued a much more ambitious theory. Rather than charge the specific statute, Chapter 499, for what they claimed the state claims was the violation, the state tried to bootstrap those violations into a RICO statute, into an organized scheme to defraud statute. And I would commend the court's attention to the cases such as Henderson versus Hertz Corporation out of the state of New Jersey, a 3-judge panel of the appellate division in which a plaintiff, a civil case, a plaintiff claims he was defrauded or she was defrauded, a consumer fraud case, because Hertz Rent-A-Car was selling insurance without a license. And the New Jersey Appellate Court, in unanimous decision, wrote, even if the plaintiff were to contend that the defendant should have revealed to her that it was an unlicensed seller of ticket insurance and that she would not have purchased the products had she been aware of those facts, we would reach the same result, and that is find no fraud. Quote, she got the benefit of the bargain. Quote, plaintiff's inability to demonstrate that she suffered any loss as a result of Hertz's sale of insurance without a license is fatal to her claim. The federal cases are in unison on this. United States versus Shelliff out of the Second Circuit, 2007. Quote, our cases have drawn a fine line between schemes that do no more than cause their victims to enter into transactions they would otherwise avoid, which do not violate the mail or wire fraud statutes, and schemes that depend for their completion on a misrepresentation of an essential element of the bargain, which do violate the mail or wire fraud statutes. And the Shelliff case, Second Circuit, citing other cases, went on to say, we conclude that no conviction under the mail fraud statute could stand where the misrepresentation was, quote, not directed to the quality, adequacy, or price of goods to be sold or otherwise to the nature of the bargain.
Are you suggesting that if the allegations, even if proven, would not have constituted a scheme to defraud?
Yes.
Let me ask then, and I think you've answered this, but let me just make sure I'm honing in on your specific argument. What element do you believe was omitted from the charging document, from the indictment in the in this scheme to defraud charge, the RICO charge?
Appendix 2 of the briefs have our proposed jury instructions, Appendix 2. And what we did in support of our proposed jury instructions is quote from the language of the cases I've just read, the Shelliff case in particular.
Right.
And here were the instructions that we requested that were not included in the charge, and they were specifically rejected by the trial judge. Quote, the false or fraudulent pretenses, representations, or promises must do more than cause consumers to enter into transactions they would otherwise avoid. The false or fraudulent pretenses, representations, or promises must be directed to the quality, adequacy, or price of the drugs to be sold. Another proposed instruction that was rejected. In addition, to be material, the misrepresentation or failure to disclose information must be one that can or does result in some tangible harm. That is, to be material, the information withheld either must be of some independent value or must bear on the ultimate value of the transaction. And so in the case of Mr. Godinez, Your Honor, what the state didn't prove was, first, there was no proof of any duty of Arturo Godinez to disclose anything to consumers. He was a wholesaler. He didn't have any privity with the consumers. There was not a single consumer who testified. There's not any evidence that any consumers actually bought this medication. There's no evidence, if there were consumers, that they were in the state of Florida. Indeed, the evidence was that the wholesale distribution chain sold these medications out of the state of Florida. So not one Florida consumer was alleged to be a buyer of these medications. So there was no evidence and no basis for finding a duty to disclose that Mr. Godinez didn't have a license, for example.
But let me ask you about that, because I understand what, I see that one of your issues on appeal is the trial court's refusal to give your special jury instruction, and I see that that's what you're arguing, and that's what Appendix 2 is. But as to the first point on appeal, which is that the indictment fails on its face, because even if proven, your argument is that it can't constitute a crime. As to that first issue, the indictment didn't explicitly allege a non-disclosure theory. So while you're arguing that that should have been part of the instruction, that was not how the state proceeded. That was not their theory, was that non-disclosure theory, and they could have proven it in other ways, could they not?
Well, the theory of the indictment, which I have, and I would refer to the court, for example, to Predicate Act Number 2. What the indictment alleges, Predicate Act Number 2 is on page 5 of the indictment. The scheme to defraud is defined as selling into the wholesale prescription drug market what was purported to be pure, genuine and unadulterated prescription drugs when in fact the said prescription drugs were at different times either counterfeit, relabeled, stolen, illegally purchased from Medicaid recipients, illegally purchased from unlicensed persons, etc. We wanted an instruction that said, so long as Mr. Godinez's defense establishes that the medications were in fact pure, genuine, and unadulterated, he's not guilty. The judge refused that instruction. So the indictment on its face required the government to prove that the medications were not pure, not genuine, and that they had been adulterated. And in closing argument, the government conceded that the medications were pure, genuine, and unadulterated. And I would refer the court to volume 27 of the transcript, pages 53 to 54. Here's the closing argument from the government. Quote, "It really doesn't matter whether any specific drug or particular drug was real, not real, effective or not effective, whether it was expired or not expired at any given time, because the real issue here is a consumer fraud. And what's important here is what would a reasonable consumer consider to be a material fact? And it doesn't matter whether in the end some of these products might have been legitimate, might have been good. All that matters is would the consumer have bought it if they knew the truth about it, because this is about consumer fraud." In his rebuttal argument, the prosecutor, volume 29 at page 3694, quote, "It's not whether it was adulterated, but whether or not the defendants bought and sold drugs with false and fraudulent pedigrees, whether they stored them in unlicensed facilities, whether they bought them from unlicensed sources, and whether these facts were kept from the consumers. That's what this issue is, okay? It's about the consumers have a right to know the material facts. That's what a scheme to defraud is all about." In the state's appellate brief to this court, at page 41 and 42 of the state's appellee brief, they define the issue, they frame it for the court. Quote, "The actual condition of a particular drug was not an issue in this case. Instead, the jury's focus was and should have been on whether the players, including Godinez, were involved in a scheme to conceal or misrepresent material facts, the nature of the pharmaceutical path to the consumer, which a reasonable person would consider relevant in a consumer transaction." So in answer to your question, Judge Sicklin, the theory of the case, as the indictment frames it, is that Godinez was selling impure, not genuine, adulterated medication, and the state conceded in closing argument they had no evidence of that. Instead, they proceeded on a theory that Godinez defrauded consumers he never met, consumers not testifying at trial, consumers who are outside the state of Florida because he didn't have a license to sell in the wholesale market, or because he acquired it from sources who were not licensed, even if, as the state conceded, the medication was pure, pristine, and genuine. We submit that's not a crime. It is not a crime to sell a consumer that which the product purports to be, whether it's medicine, whether it's widgets, or whether it's insurance, as in the Hertz versus Henderson case. It is only a fraud if the consumer doesn't get what he or she thought he was paying for. And in this case, as to Mr. Godinez alone, it is crystal clear that the only thing he sold, if you accept the testimony of the witnesses, was medicine that was pure, genuine, and in no way contaminated or adulterated.
Well, counsel, let me try to do a hypothetical here. What if a person wins a Mercedes-Benz E-Class? They win it, and they take it down to Mercedes-Benz of Palm Beach and say, I won it, but I'm going to give it to you. There's 0 miles on it. Mercedes-Benz puts it in his showroom, sells it as a brand new car. The person's getting a Mercedes-Benz E-Class, but isn't there some element of fraud involved there? I mean, if that car is just put on the showroom floor as a brand new car?
If it in fact is a brand new car, no mileage on it, if it in fact is an E-Class manufactured by Mercedes, whether it be in Germany or Georgia, wherever the plant is, as long as it is that which it purports to be, of course it has to be new, and I'm assuming with your honor that the car is new, it hasn't been driven, otherwise it's not new.
And put it on a flatbed.
If it's brand new and it is a Mercedes and there's nothing wrong with the car, then there's no fraud on the consumer who buys it. He gets the warranty, and it's the Hertz case. The Hertz case is just that, providing insurance to consumers even though they're not licensed. And so I don't see how the government survived a judgment of acquittal, but in all events, at a minimum, we urge the court to reverse because the jury wasn't properly instructed. I see that my time is up. I'd like to reserve the balance of my time for rebuttal unless there are other questions at this time.
All right, thank you. I'll give you a minute for rebuttal. Counsel?
Cynthia Commerce on behalf of the state. I would like to point out that he was not charged with carrying a license or failure to, whether it was pure or genuine, or sold a pure or genuine drug. He's being charged with materially misrepresenting and concealing material facts to the consumer. Basically, this is a consumer fraud case, and the whole issue is that he broke the chain of the regulated chain, government chain. These drugs came from improper channels, and by the very fact they came from improper channels, we do not know whether they were, in fact, pure, genuine, or whatever. But even if they were, that's a material fact that would affect a consumer's decision, drug consumer, when purchasing these drugs. If they found out that these drugs were stored in an unlicensed nursery, sitting out and were then put into the stream of commerce, they would not, if they were on the shelf next to each other, they would not purchase a drug that was stored in a nursery where they don't know the temperature or how they were managed or who handled them, versus somebody who was regulated by the government who made sure that they were stored in proper sites, that they were being inspected, and that they were stored properly. I mean, they were put side by side on a shelf. You're going to have a consumer that's going to say, I don't want that one over there because I'm not sure if it's safe. I don't know. And that's the thing with Godinez. We don't know where he got these drugs. There was testimony that he got them from his ALFs. He got them from the street, meaning on the ALFs, meaning he purchased them from Medicaid patients, he purchased them from doctors, and then he gave them to Carlo to sell, who then put them into the stream of commerce. So by the very essence of how he obtained these drugs, we don't know if they were safe or pure. It's impossible to prove.
Does the state concede that these drugs were pure, genuine, and unadulterated?
I'm not going to say we concede that. I'm going to say nobody knows. That wasn't the issue. It wasn't the issue. He wasn't charged with providing pure or not providing pure drugs. He was charged, or the theory of defense was that he broke the chain, the regulated chain. These drugs came in from improper channels. And I would also point out that they talk about Chapter 499 and that we sidestep Chapter 499 or whatever. We went under a general consumer fraud statute, the federal RICO statute. The state could have charged under Chapter 499. They talk about that Chapter 499 only dealt with where the drugs were impure, they had contaminations and all this other stuff. Well, if you look at Chapter 499, the 2002 version of it, there are sections in there that basically say if a drug is stored in an unlicensed facility, it's an adulterated drug. Godinez had these drugs. There's testimony from I think Mark Siegel, that he picked up these drugs from his nursery. Then it also says if you have false or fraudulent pedigrees, that's a prohibited act under the statute. And Section 499.01216 talks about record keeping, and that you must keep an audit trail, or in other words, a chain of custody. Who handled this drug? Who in the line, who was licensed to handle this drug? You're not supposed to sell to unlicensed or buy from unlicensed individuals.
Counsel, how would you define the elements in a basic way? The elements of the crime that this defendant committed?
Which one? The RICO, the conspiracy to commit RICO,
The RICO first.
Okay. On RICO.
Or either one of them, really. I want to get at the basic element of the crime, the criminal offense.
On RICO, for instance, you have to prove that he associated in an enterprise. And this enterprise is that everybody's involved in making money from repeated criminal activity. They wanted the actual scheme was to sell drugs for a profit that were acquired from illicit sources. Then you have to prove that he participated indirectly or directly in the enterprise. And he does not have to, they talk about 2 predicate acts, but he was vicariously liable for the use of the mail frauds by other members in the scheme once he became a member or a party to the scheme. So he joined the scheme to defraud. He understood and knew what it was about. He took part in the scheme by providing these drugs to Carlo. And others did their part to help make this scheme successful. I mean, when he sold these drugs to Carlo, obviously he knew that Carlo was going to turn around and then resell them. And the only way he could resell them was to provide a pedigree saying, I got this from a licensed person, a legitimate source. So obviously he's not going to put down, Godinez gave me these from his nursery.
Yeah, so the linchpin of all of the offenses is going to come down to a definition of fraud, is it correct? I mean,
It's general fraud, consumer fraud.
as appellant.
And this is a material fact. And he talks about the financial loss being the core of the mail and wire fraud statute, but also is to punish the intent to obtain money or property from a victim by means of fraud and deceit. And that's from U.S. versus Maxwell, 579 F. 3rd, 1282, 11th Circuit case. So it's not just that, he tries to talk about the fact that he didn't have a consumer come in and say I was defrauded. Well, there's an intent here to defraud them, and this is a material misrepresentation or concealment of facts. And that's from the fact that these people had to produce fraudulent pedigrees because they were coming from the wrong source. They couldn't say, hey, I got it off the street, or I got it from so-and-so. So they had to produce this paperwork to make it look legitimate so that they could sell it to other wholesale distributors. And in doing so, that's the fraud. And then it ultimately ended up...
And I'm playing devil's advocate, but the average consumer is not really aware of the requirements of Chapter 499, and I doubt if the average consumer knows where the pharmacy at Walmart got its drugs ultimately from.
Mm-hmm.
So how does that fit in with?
Well, they're the actual victims in this case. I mean, because they were the ones that were buying these drugs and paying full price for what they thought was legitimately acquired drugs.
Who made the representation to them that it was legitimately purchased through the proper chain?
Well, once they got into the stream of commerce and then these pedigrees were going down the line, they eventually would be sold to the end users. Remember, the pharmacies, the doctors, or whoever, who then would sell or dispense these to the consumer. So once they made it into the stream, they were being represented as legitimately acquired drugs. And that's how they got to the consumer fraudulently.
But who's doing the representation? Is it Carlo or is it Godinez?
Godinez did not do a direct representation, but he relied on others in the scheme to carry it out to make it, because if Carlo did not do this fraudulent document, this pedigree, it would not be resold. In other words, he couldn't sell it to Carlo for a profit. Carlo couldn't turn around and resell it for a profit. They all had to do their part, and their part was he had to create a pedigree that made it look legitimate when it wasn't.
Was there testimony that Godinez knew Carlo was creating these fraudulent pedigrees?
That could be inferred. That's circumstantial evidence that can be inferred from the evidence. What you've got, like I said, is that he was buying these from illicit sources. He was getting them off the street from HIV patients, doctors, and then storing them at his facilities. But then he would give it to Carlo, who he knew was going to turn around and resell it. And the only way that he could resell it would be to make it appear that he got it from somebody else. And the fact that, if you notice, he was paid, he claims, well, I was just a broker. I just put these two people together. And, that was a legitimate business. But you can have a consciousness of guilt based on the evidence that was presented. I mean, you've got his tax bill being paid off by these corporations. You've got South Florida yachts. He bought a yacht. They paid 2 checks to the yacht. You've got his brother-in-law receiving thousands of dollars in checks around the same time he was doing business. You've got his brother-in-law's friends at the gym cashing these checks. And then you've got him not legitimately reporting this income on his taxes.
That's a different issue. But what evidence do we have that Godinez knew what Carlo was doing with these drugs?
I'm sorry.
What evidence is there that Godinez knew precisely what Carlo was doing with these drugs?
He knew Carlo was a wholesale distributor, and he's selling him...
A distributor where? I mean, was he a distributor for an overseas market, for example?
No, he had a Florida license, and he was distributing drugs out of Florida.
But he
So-
did Godinez, was there evidence that Godinez knew that Carlo was distributing these drugs within the state of Florida as opposed to somewhere else?
Well, if the transaction occurred in Florida, then Carlo had to have a license. And if he got a license, he had to verify to get that license, he would comply with federal and state law, and including Chapter 499, meaning that he knew that he had to acquire these drugs from licensed sources. He
Okay,
couldn't
that's
just pick
Carlo.
them
I'm
up.
talking about Godinez. What information, or what testimony is there about what Godinez knew about what Carlo was doing with these drugs?
Well, it's all circumstantial. I mean, it can be inferred from the evidence. I mean, if he's buying quantities of drugs, you know Carlo isn't going to sit there and consume them himself. He's going to resell them for a profit. So otherwise, he wouldn't buy them from him because he was buying them and then reselling them for a profit. That's part of the scheme that they were all going in. It's inferred from the evidence. There's no direct evidence. So, but then, I mean, you just got, the scheme is very complex in this case. You've got multiple people being involved, doing their part, all making it appear that these drugs are legitimate and they are being put into the stream of commerce. And these acts, these people that are involved are in Florida. I mean, and you've got, for instance, against this particular defendant, we've got 3 different people that came in and testified and said, hey, Godinez is supplying these drugs. I first had knowledge of that. Mark Novosol, Mark Siegel, and Oviedo Pena, they all said that. And so he knew he was supplying these drugs to Carlo, and Carlo was putting them back in the stream and making them appear to be legitimately acquired.
Was Godinez's actual sale of the drugs to Carlo, was that prescribed by law?
No. Godinez was not licensed. You can only buy under Chapter 499. You can only buy from licensed individuals. You can't buy off the street. You can't buy from unlicensed individuals.
I understand. My question is, was Godinez's sale of these items to Carlo, was that a violation of law?
Yes, under Chapter 499. They were stored in an unlicensed facility, so they were therefore, again, there was contrary to Chapter 499. They had false or fraudulent pedigrees. They were purchased from unlicensed sources. And under 499.00514, the prohibitive acts prevents you from distributing drugs not authorized or purchasing drugs from somebody not authorized to distribute legend drugs. A patient, a pharmacy, clinic, doctors are not permitted to distribute legend drugs. You can't purchase from them.
Counsel, to the extent that certain of the drugs were what they purported to be, a particular drug, is the state's primary concern in terms of the impact on the victim concerning the market price, the reduced market price that would have been paid? I mean, is that the concern, that it would affect, obviously, the person might not pay as much for it? I mean,
I don't think any person would buy these drugs, because by the very fact they came out of these regulated circle, this protection that the government has in place to make sure these drugs are in fact authentic, stored properly and everything, we don't know if they were genuine or not. He's saying they are. Oh, there's no way to prove that, but it's still outside the channels, and those channels are in place to ensure that these drugs are safe and that they purport what they're supposed to do and that they're handled properly, and that people that are supposed to be touching them touch them, not other people from the street or whatever. So I personally don't think.
But isn't that a regulatory concern? I mean, isn't that a concern for the licensees, for the licensors, for the State Department of Health and et cetera, isn't that a licensing matter? A licensing concern?
It can be a licensing matter, but that's not what he was charged with. He was not charged with not having a license. He's charged with providing, obtaining these illicit drugs and selling them to Carlo for a profit. Okay. So let's see, getting them from illicit sources. So this is not a licensure violation case. And the adulteration part of it is kind of it's describing the scheme, because at times they're adulterated because maybe they were counterfeit, or because they were stored at a license, or because they had a false pedigree. Not all these things were happening maybe in this particular defendant's case, but that describes the scheme, the adulteration part of it. That he's being charged, I mean, what the whole theory was that he broke the chain.
Are you saying that if the drug passes from one individual to another who is not, and the licensure is the only difference, okay, it is the pure, the genuine drug, and it goes through somebody's hands that is not licensed, that constitutes an adulteration? Yes.
You are not allowed to purchase under Chapter 499, and this is 2002, from a unlicensed source. You cannot, and an unlicensed source would be a patient, pharmacy, a clinical doctor, or even from the street. That's not a licensed source. And whether, like I said, whether it's pure or not, he still was outside the chain of regulation. And we don't know, because he was outside the chain, we don't know that these were pure and that they were genuine and properly stored.
So what if you had a person who had a license, but it lapsed, and for 6 months they didn't go down and do whatever they had to do to reinstitute it, and they continued to do business while their license was lapsed? Would that be the same crime?
Well, I think it comes down to intent, criminal intent being inferred from the evidence. And maybe you could argue in that case that it was not, that they criminally did not intend to defraud the consumer. In this case, you have criminal intent based on the fact of his consciousness of guilt, the fact that he was not paid directly, the fact that his taxes were being paid, his boat was being paid, the fact that he tried to stay out of anything that had to do with this. He was hiding, in essence, hiding behind all this that was occurring. He didn't want to be, he was not named in any of these pedigrees. I mean, you basically have all that inferring a criminal intent on his part to defraud the consumer.
Okay, unless there's any questions, I'll give you some time.
Your Honor, in answer to your question, there was no evidence that Mr. Godinez was involved in the subsequent distributions by Mr. Carlo, but the undisputed evidence was that all of Mr. Carlo's wholesale business sold the medications outside of the state of Florida. I would commend the court's attention, therefore, to the testimony of the government's own witness, Sandra Stovall, volumes 13 and 14, where she concurred with the following observations. Medicine in this chain is handled by common carriers, UPS, the Postal Service, boats, planes, people that are unlicensed. And so while the state would like the court to have this lure of fear permeate the courtroom, indeed, it was undisputed that the medications, so long as they remain not tampered with, in the bottle, hermetically sealed, it doesn't matter who touches the box. And consumers are not defrauded because, as we used as the example in trial, Frankie's courier service, who's local and has no idea what he's transporting, takes custody of the box and sends it down the line. There's simply no contamination by virtue of who touches the box. I would commend the court's attention. Oh, by the way, we established that sales representatives of manufacturers, they stick these boxes in the trunks of their car, put them in the garages of their home, and that's perfectly okay. And so it's quite clear that the state's theory is purely about licensing. It becomes contaminated or adulterated, in their words, just because, as Your Honor pointed out, the wholesaler's license lapsed. And if his license lapsed, he can be charged with a Chapter 499 violation, but he can't be charged with fraud. The pedigrees. In most states in this country in 2002 had no pedigree laws. None. There was no requirement to maintain pedigrees at all in the states to which Mr. Carlo was sending medication. The federal law was suspended during that period of time. The federal agencies had stayed the rule implementation. And so there was no expectation by consumers. To answer Chief Judge's question about does the consumer at Walgreens have any expectation that the goods came from a particular channel? Absolutely not in 2002. Absolutely not. What the consumer did have an expectation of, and should reasonably be able to expect, is that what's in that box is the genuine, safe, and effective medication produced by the manufacturer. And in Mr. Godinez's case, that was the evidence, that indeed his agreement was only to provide safe, effective, and genuine medication. Finally, the business about patients putting medication back in the stream. I commend the court's attention, volume 14, page 1756, what's known in this country as the repository program. Patients can donate their medications from the medicine cabinet to in certain states, and it's given away to less fortunate people. Because consumers understand that so long as the medicine hasn't been tampered with, hasn't been contaminated, it's genuine, and there is no fraud under those circumstances. Unless there are any other questions, I would submit on the briefs.
Thank you very
Your
much,
Honor.
Counsel. Thank you very much, both of you.